Yeah, good morning, Doctor, and good morning to Rufai.
Good morning, sir.
Okay, there are many strands to this ruling from the Court of Justice Wite, Federal High Court in Abuja, taking us back to the Akeredolu Jegede case in Ondo State.
Exactly.
Taking us many decades back to the ruling made by Lord Denny in Mark 4 versus UAC, about how nothing
UAC.
can stand on nothing.
You can't put something on nothing and expect it to stand.
Yes. So please help us look at all these strands, the implications and who the beneficiaries are, because it will appear that there are some beneficiaries. Ademola Adeleke of the PDP in Osun State will certainly be a major beneficiary, I think.
Yes, thank you, Dr. Ruben. If you remember, sometime since July 2021, Festus Keyamo did write, he wrote a memo on the legal implication. That was immediately after the Supreme Court judgment on Akeredolu's case, where you had a split judgment of 4 against 3. And Festus Keyamo looked at the legal issue and the legal quagmire and did raise an alarm. He also was supported by Senator Babafemi Ojodu and Itai Nang in that position, even though the Attorney General and some other persons disagreed. But unfortunately today, the court of Justice Emeka Nwite has proved Justice Festus Keyamo SCN right in his ruling on this matter. Simple, Justice Festus Keyamo's position then was that by virtue of Section 183 of the Constitution, an executive governor, that section forbids an executive governor from holding another executive position or collecting, holding a position that will enable him collect salary. These interpretations, Doctor, are disjointively so in this case, what the court is saying, permit me to quickly read the provisions of Section 83 for the benefit of our listeners. Section 83 of the Constitution simply says that the governor shall not, during the period when he holds office, hold any other executive office or paid employment in any capacity whatsoever. The argument of the Attorney General then was that the position of Boni was an ad hoc position and that he wasn't paid for the job. But the argument of Keyamo and Babafemi Ojodu was the fact that there is no decision taken by a national chairman of a party that Boni hadn't taken. So the fact that is described as a caretaker committee to organize an extraordinary committee does not mean that he's not taking executive position. In fact, a lot of the ordinary man would see him as an acting executive chairman of the party. And Keyamo did advise that what the party could do was to call the National Executive Council of the party to reconstitute that extraordinary caretaker committee and then remove anybody who is holding an executive position, governors. But the party, disregarded that position. Even there was a suit also that challenged the candidature of Oyetola on the ground that is a member of that committee. Although that suit also was dismissed by the Federal High Court. But today, we are seeing a different Federal High Court saying that there's a violation of Section 183. And what that means is that every decision, like you had said, every decision taken, if this judgment is sustained, it means that every decision taken by that committee, including the congresses and the convention organized by the committee, amounts to a nullity. That is going to put APC in a quagmire situation. So, but we'll wait to see, because matters of this nature will definitely end at the Supreme Court. We'll wait to see how the Supreme Court will look at it. But some persons also have argued that considering the fact that the primaries that produced the APC presidential flag bearer was conducted by Adamu, and that the matter, being statute barred at this stage can no longer be questioned. But we should also remember that The issue was raised in a post-election matter in Akeredolu's case. The judgment of the Supreme Court was that the Buni was not a party in that matter. So now there is a clear reading to that section. So if the other party, let's say PDP or Labour Party, decides to raise that issue after the election, and if the Supreme Court sustains that position, then it might be pose a big challenge for the APC.
Let's talk about the severity of this challenge, for the APC. Because with what you're saying now, is that there are going to be far-reaching implications. Even the Akeredolu case, a lot of people were not happy about the judgment, and they said he just scaled based on technicality. So let's expand this conversation and even let's look at these far-reaching consequences, because it's also going to hit Ekiti State. So are you saying that somebody like the SDP candidate in the former elections in Ekiti State cannot go to court and use this as a bait to challenge the governor that's about to be sworn in Ekiti State? Let's look at the far-reaching effect of all of this.
If it wasn't for the Ekiti case, if that issue, mind you, election petitions are no longer amended. Amendment of petitions are no longer allowed by the provisions of the Electoral Act. So if it wasn't already an issue in the election petition filed by the candidate of the SDP in Ekiti State, then that is a foregone and concluded issue. He can no longer amend his petition to include that prayer. And if he didn't file any petition, I am sorry, it is too late in the day for him to rush to a tribunal to be filing a petition now. But like I have said, the far-reaching implications are grave if this position is sustained. I keep quoting Babafemi Ojodu. I completely agree with the positions of Babafemi Ojodu, then senator, a former senator of the Federal Republic, that even though, immediately after the judgment, Akeredolu dismissed the judgment, even the APC lawyer then dismissed the judgment that the dissenting judgment of a Supreme Court cannot form the basis of a decision. But the warning of Festus Keyamo was not that the dissenting judgment was the position of the law, was that it might be the position of the law in subsequent matters, even though no two cases are the same. And that is what has played out in the case of Oyetola today now. That, remember, Boni also submitted the name of the candidate of the Ekiti State APC candidate to INEC. And he organized the convention that produced Adamu. So if the court sustained that position that Buni, by all intent and purpose, and by the provisions of Section 183 of the Constitution, does not have the power to hold that position, being on the ground that he's an executive governor, he can no longer hold an executive position in another organization, whether paid or unpaid, then it means that every action taken by Boni as the caretaker committee chair of the APC Extraordinary Committee, it's a nullity, amounts to a nullity. Every decision taken by him amounts to a nullity, including the Congress and convention that produce the current executive members of the APC. That would be, I would wonder where the APC would be, because all the candidates that emerge through congresses, and these congresses produced leaders at the state level that subsequently produced candidates for election, including the national candidate. What it means is that all of that will amount to a nullity, which was the warning that Festus Keyamo was drawing the attention that Festus Keyamo was drawing the party to at that time. But they allowed politics to prevail, and today, we have had the first judgment now. Let's see what the Court of Appeal will say in that regard, and then subsequently the Supreme Court. But I also will not close my eyes to the fact that a Federal High Court in Rivers had ruled otherwise earlier on. But this is the latter judgment in time. So what you have two conflicting judgments of courts of coordinated jurisdiction. We'll wait for the Court of Appeal to see how the Court of Appeal will take a bite on this current matter. It's a bit frightening for me.
It's a very living, subject, and the true test is in its implementation. The Supreme Court, in the Akeredolu Jegede matter, may have taken the position that it took, because Buni was not joined in the suit. I think that was the ruling. And then you refer to the, minority judgment by Justice Mary Odili, JSC, as she then was. But the Supreme Court now has an opportunity. It may not reverse itself in a particular case, but if this matter goes all the way to the Supreme Court has, the opportunity to reverse itself in the precedence that was established previously. What do you think is likely to happen?
What the Supreme Court simply said in that matter was Buni was not joined. The Supreme Court did not make a pronouncement on the majority decision, didn't make a pronouncement on those issues raised. So there is no position. But what the Supreme Court simply said was that since Buni was not a party in the matter, he could not go into that issue. And for me, it was a signal to the point that this can be an issue. The fact that the first thing is what amounts to an executive position, because Section 183 is talking about executive position, taking executive decision, or you are holding a position whereby you are collecting salary. That's of a minister. So what the Supreme Court will be looking at is what amounts to executive position. The position, even though the party had argued that the position of Buni was that of an extraordinary, an ad hoc based position, an extraordinary caretaker committee chair to organize a Congress. But we also know that the position of Buni then was beyond just organizing a Congress. That's what Justice Nwite is also querying. The position of Buni then also amounted to an executive position by submitting the names of candidates to INEC for an election, which was what the PDP queried in the case of Ondo. That is an executive position. That is a position that is exercised by the party national chairman. INEC portal, we all know, it's a notorious fact that INEC portal, the code to INEC portal to submission of name is only accessible to the chairman of a party and the secretary of that party. So by submitting those names, you can say that Buni was exercising an executive power. And then also, Article 7.4 of the APC Constitution also forbids a governor holding an executive position in the National Working Committee of the party. So all of these are the issues that would, come up at the end of the day. I doubt, these are my opinion, I doubt if the Supreme Court, because it has not even, we can't say it will overrule itself because it didn't even take a bite on the matter. I just said this person was not joined as a party. The argument of some of the lawyers for the party also is the fact that you cannot join Buni in a matter that is a post-election matter. But that also is an argument that the court will need to look at, that APC being a party in the matter already and Buni not being a candidate in the election cannot be joined as a party in a matter. That's another technical ground that also might need to be looked at. But if there are issues that borders on his action as a chairman or as somebody holding an executive position, whether the nomenclature describes him as executive position or a caretaker committee or a committee to organize extraordinary extraordinary Congress, these are nomenclature. So it is the way the court would describe what actually the position that he holds or the conduct of that position that will matter at the end of the day. That's why a lot of people are still, skeptical that this might signal danger. But I just wonder how they would, I pray, like you had said, how they will play it out. But I do not see the Supreme Court, if this matter is properly argued, I do not see the Supreme Court looking the other way, because you can't close your eyes to the fact of the action taken by the person, no matter how described, how the position is described, whether it is described as an executive position, because the court looks at the intent and not just the form of what was described. You can appoint somebody as a caretaker committee to organize a committee or a Congress, but if that person goes beyond performing executive function and you did not query those executive functions, and those executive functions are latent, like we have seen, then that's another problem also in the course of interpreting the role that he has actually played.
Well, but what is tantamount to executive functions were performed, like you just stated there? So why are we saying, okay, they might not be able to define it properly and say, okay, he was a caretaker person, but he signed forms in the first regard. And we cannot remove that fact from this conversation.
Yes, that's what I'm saying. That's where, because the argument of the party at that time, including the argument of the Attorney General, was that the Buni was not, that means if you go by the letters of Section 183, forgetting the spirit of Section 183, that members of governors who are members of Governors Forum were violating Section 183. And the interpretation is that the position of a governor who is a member of Governors Forum does not extend beyond his state. A member who is a governor is a member of a Governors Forum cannot go to take decisions on who become a candidate of a party in another state. But we also know that there were parallel congresses in APC at the time Buni was the head of the caretaker committee, and any committee recognized by Buni was the authentic committee. He signed form for candidate. He submitted the names of candidates. These are decisions taken solely by chairmen of political parties. So all of this, that's what I'm saying, is that I want to see how all of these arguments will go back and forth. But I also raise the fact that the sole issue, another technical issue would be whether you can join him as a party in a matter that is a post-election matter. Because the Supreme Court had ruled in Akeredolu's case that he wasn't a party, and so they couldn't look into the matter. He needed to come defend whether the action he is taking are executive action or action spelled out by the letter or the authority that appointed him as executive committee, as a caretaker committee to organize an extraordinary Congress. So that's what I'm saying. It depends on the way you want to look at it. But to the ordinary man, Buni was simply an acting executive chairman of the party, irrespective of the nomenclature that you want to give to him, because he played the role of the acting chairman of the party in the absence of the national chairman when they had their crisis that saw the exit of Oshomole. So we're coming back to Justice Uwite now. Justice Uwite had ruled that those actions amount to a contravention of Section 183 and amount to a nullity. So ab initio, what it means is that by the provisions of the law of the Constitution today, Buni never existed. And any action taken by somebody that never existed amounts to a nullity.